Thank you. My Lady and my Lords, I was dealing with the respondents' criminal convictions, and I had reached the point where I was going to tell you that it is clear that Mrs. Gallagher, in her completion of the self-disclosure form for the purposes of employment with the Trust, misstated the true extent of her criminal record. While she ticked the box and admitted to having been convicted of any offence, she, in another part of the form, provided particulars of one offence only, that is the earlier offence, and didn't refer to it in plural, and didn't refer to the later two offences. She has explained that her approach to the personal declaration form was flawed. She only put down one conviction on her account because she didn't think it was major and she thought that it had been wiped. Upon receipt of the certificate produced by Access NI and discovery of the inconsistency, the Trust withdrew the offer of employment. And as my learned friend Mr. Call suggested yesterday, it is common case that the offer of employment was withdrawn because, in the view of the Trust, there had been a serious breach of trust.
It looks as if, because of the sequence of interviews, they would not have withdrawn the offer simply on account of the convictions themselves. One can't be sure, but that seems to be the case from her account of what happened at the first interview.
My Lord, that appears to be plain, and I think it's given added weight by the correspondence issued by the Trust in the pre-action protocol process. And indeed, while this was, that is the breach of trust was the operative reason for the withdrawal of the offer, we do not accept the appellant's submission that the respondent's failure to engage properly with the disclosure process acts as any kind of barrier to her right to challenge the lawfulness of the imposition of the disclosure process upon her. Furthermore, we disagree with the closely related submission advanced by my learned friend that consideration of her recent employment history indicates that she has little to complain about because there is no evidence that criminal record disclosures have had a detrimental effect on her ability to obtain employment. While that is a feature of some of the other appeals before my Lady and your Lordships, it is not explicitly a feature of this case. Nevertheless, we submit that both of these points fail to truly appreciate the nature of Mrs. Gallagher's challenge. Firstly, Mrs. Gallagher does not contend that the scheme has operated as a bar to employment in her chosen field. Rather, she claims that regardless of any impact on her employability, there was an unjustified interference with her right to privacy, which is significant of itself. She makes that case, my Lady and my Lords, as you will have noted in our written case at MS 8147, having regard to the fact that her minor and aged offending history, allied to the nature of the employment which she was seeking, means that her criminal antecedents are completely irrelevant to any reasonable assessment of suitability. Yet, at the operative time, there was no mechanism available to her to demonstrate that this was the case or to challenge the requirement to disclose. In this respect, I would refer to the remarks of the Court of Appeal in Northern Ireland, which you will find in the Core Authorities bundle at volume 2. Tab 11, and at paragraph 81 thereof, I should say, the MS number is 563. This is her point that it was inappropriate to require her to make the disclosures. And at paragraph 80, if I can start there, the court draws attention to my learned friend's contention that more than one conviction can portray a propensity or recklessness towards the criminal law, and they say that that does not persuade us. That may be the case, but the absence of any mechanism to assess this in the individual case illustrates that the blanket nature of the provision goes much further than is necessary to protect the aim of the legislation. There is no attempt to carry out a balancing exercise between the interests of the person concerned and the community at large. And then at 81, it cannot be appropriate that two minor offences, as opposed to only one minor conviction from many years before, which the individual may well have put behind him or her in all other respects of their lives, should suddenly appear on a criminal record relating to work with vulnerable adults or children without any assessment whatsoever. It is the lack of consideration that makes this scheme indiscriminate and therefore disproportionate. In my respectful submission, it doesn't appear to have struck the appellant that the better point to be derived from the respondent's ability to obtain employment, albeit largely agency work, notwithstanding the disclosures that she has been required to make, is in fact the patent irrelevance of those convictions to the question of suitability. As my lady and lordships will appreciate, the scheme is mandatory in nature. A condition precedent to gaining employment in this particular field is, for all practical purposes, to do as the scheme says. Therefore, contrary to the appellant's submission, the true essence of the respondent's case is that violation of her Article 8 rights occurred without more because she was obliged to disclose highly sensitive personal information which revealed publicly that she had a criminal history. Such an interference in our respectful submission is profound and serious. To disregard this is to dilute the significance of the nature of the information concerned and its diminishing personal effect. It has been recognised, and I think I'm right in saying my learned friend Mr. Southey referred to these authorities this morning, that in RL, to take one example, Lord Hope, citing the Strasbourg jurisprudence, emphasised that data of this kind is personal in nature, particularly where it has receded into the past, where it forms part of a person's private life, which must be respected.
What is the rule of law which you say offends against Article 8? I mean, there seem to be two candidates. One is that there isn't any law against asking somebody about their convictions, and the other is that you can't tell lies, generally. I mean, as a general rule in law, you cannot tell lies. Now, those two propositions, the absence of a law against asking the question and the existence of a law against telling lies, are the legal propositions which you say conflict with Article 8. Is that correct?
Well, it's the requirement imposed by the state which forces the respondent into an arena.
Which requirement?
It's both parts of the scheme. They operate together. They are, in essence, two pillars supporting the one scheme, and it's
neither of them are part of the scheme. The proposition that an employer is entitled to ask this question is not part of the scheme. The scheme deals with certain consequences and entitles the potential employee to give incomplete or even true answers in certain circumstances, or to treat the question as not relating to them. But the proposition that the employer can ask the question and that the potential employee mustn't tell lies, neither of these are features of the scheme. They're propositions of the general law.
yes, but
Are you submitting that the general law has got to ban such questions in order to comply with Article 8?
I'm saying that the fundamental right existing within Article 8 requires that that approach, that, as has been recognised in the cases, such as the fundamental nature of the right at stake, the state must step back and assess whether it's proportionate to require information of this kind to be disseminated as a condition precedent to securing employment. I was going to go on to say that as well as the dicta in L, it has of course been recognised in S and Marper that data of the kind with which we are concerned, criminal conviction data, is in essence fundamental. It's fundamental material and warrants protection on that basis. In addition to the impact on the respondent of having to disclose, in the sense that it left her without the cloak of privacy, the impact was not without material or practical impact. She lost the benefit of direct employment with the trust, for although she was responsible for misstating the extent of her criminal record in answer to questions posed to her by the requirements of the scheme, she ought not, in the view of the courts below, to have been required to engage with the scheme in the first place. Furthermore, it is appropriate to observe that the respondent's unhappy transaction with the trust has caused her a measure of worry and precipitated a reluctance to apply for further posts with the trust. This is set out in her statement at page MS 8309, paragraph 17. This resembles the chill factor acknowledged by Mr. Stacey of Unlock, which was examined yesterday briefly, which can be found at tab 136, MS 4852, as part of the evidence gathered by the House of Commons Justice Committee. Moreover, while it is appropriate to acknowledge the criminal record disclosures which operate to create a practical impediment to employment may be considered to represent a particularly grave infringement which doesn't apply with Mrs. Gallagher, it is also important to reflect the fact that there can be no guarantee that the continued application of the scheme to the circumstances of the respondent, notwithstanding the intention to now only use the police national computer and notwithstanding the availability more recently of a review mechanism, will not necessarily affect her at some point in her career in terms of employment opportunity. I should say, my lady and my lords, you will immediately recognise that while the availability of a review mechanism, if you like, might tackle the vice on the certificate side of the House, and indeed the Police National Computer approach may also helpfully affect the certificate side of the scheme. She is nevertheless required, and as the rules of the scheme apply, will continue to be required to make self-declarations anytime she seeks employment, which is of course on the rehabilitation exceptions order side of the scheme.
Well, focusing on the certificate side of the scheme, as you put it, is it appropriate for us to make a declaration of incompatibility now that the changes have been effected? Section 4 of the Human Rights Act gives this court and other courts the power to make a declaration of incompatibility. It doesn't impose a duty. And now that what you describe as the certificate side of the scheme has been overtaken by provisions to which you've just referred, is it appropriate for us to make a declaration of incompatibility?
Well, I think to be absolutely precise, as I understand the appellant's approach to this, I think what they're telling us is that in all likelihood, the Police National Computer cannot be harvested to provide information about non-recorded offences. So there's a little bit of uncertainty around that.
Well, I didn't think Mr. Cole was at all uncertain about his statement that your client would not now be caught because her offences are not recordable offences.
The other side of it, my lord, if I may say so, is of course the option, as was looked at this morning, of introducing into the certificate the soft intelligence material. So it's at least possible that the police would seek to introduce her convictions.
That would be catered for, would it not, by the review that's available to her?
Well,
it should be if the review procedure is operating
I think
correctly.
In terms of that transaction, she has the right to make representations to the independent reviewer. The independent reviewer can elect to delete or remove the material. And at that point, as I understand it, my learned friend will correct me if I'm wrong, at that point, assuming a deletion of the material, it will go out to the police so that they can satisfy themselves that the deletion was appropriate.
Yes.
Now, so that's the way of it, and it's not entirely clear to me that the respondent would have a right to involve herself again if the police have had their say.
Yes.
So I think the short answer to your question, my lord, is that just satisfaction in this case, on balance, would seem to dictate the need for the avoidance of all doubt to grant a declaration of incompatibility.
Remind me, would you, do we know what the effect of the current Northern Irish review scheme is on the duty to answer the employer's question?
None at all, no effect. I see my learned friend nodding.
That's rather what I thought.
I think I've got that one.
Yeah.
Got that one right. It really, my lord, does not sound at all on the self-declaration element. I will go on to just touch briefly on the review mechanism at the conclusion of my submissions, but I will be making the point, I'll herald it now, that really the failure to cover the self-declaration element or pillar of the scheme represents an incongruity and for all practical purposes, it might be said that obtaining a deletion of your convictions from the certificate amounts to a rather pointless exercise if, on the other hand, you have had to complete an employment application form with a self-declaration pro forma attached to it, and if the obligation under the exceptions order is to answer truthfully and accurately. I have made the point before I broke off that there's no guarantee that the continued application of the scheme to the circumstances of the respondent will not adversely affect her at some future point in her career in terms of employment opportunity. The cases are well supplied with the judicial appreciation of the well understood experience that even when the criminal record certificate records a conviction or caution for a relatively minor or questionably relevant offence, a prospective employer may well feel it safer to reject the applicant. That was the observation of Lord Neuberger in L, cited with approval in MM. You can find that most conveniently at tab 26 MS 1115, that's treble 15 at paragraph 200. Furthermore, in T, Lord Wilson appeared to accept the concern that while Parliament thought it preferable that the employer should judge the relevance of the disclosure, this was not without risk or difficulty. He asked, rhetorically perhaps, in these days of keen competition and defensive decision-making, will the candidate with the clean record not be placed ahead of the other, however apparently irrelevant the offence? Tab 21.
Well, I think Mr. Southey has...
We've already seen that.
Must have been sleeping. I beg your pardon. Notwithstanding, it was at the heart of the appellant's remarks yesterday that the employer's role is one of key importance. This was said to be justifiably so in the context of public protection. Furthermore, it was suggested that the scheme does not operate as a bar to employment, and somewhat quaintly, that disclosure should be viewed as opening a door to discussion between employer and prospective employee, and that to suggest that employers do not approach these matters seriously and appropriately is to do them a disservice. As I've said, the courts have expressed their reservations about this, not least, I suspect, because of the absence of enforceable safeguards. Although in Northern Ireland we have a well-intentioned code of practice which directs employers to appropriate use of the disclosed information, and I think that is perhaps by contrast to the position in England and Wales, it is likely to be a limited tool. As the appellant has acknowledged, it may carry out compliance visits, but it does not see it as any part of its responsibility to police the decisions of employers arising from disclosure. The code only requires that registered persons cooperate with requests from Access NI to undertake assurance checks as to the proper use and safekeeping of disclosure information. We can find that at Core MS 8547. It is noted that Mr. Clark, in his statement for the department at MS 8412, states that it is not the role of Access NI to provide training on the interpretation of criminal records to either employers or applicants. He says that it would be well nigh impossible for Access NI to provide meaningful advice on the information contained in a disclosure certificate that would go beyond what is self-evident. Furthermore, the offence that was referred to yesterday, the offence under Section 124 of the 1997 Act, creates an offence in the context of unauthorised disclosure and does not deal with the situation of how employers and other registered bodies interpret or apply criminal record information. In any event, I go back to the concern with which I started. The vice is not only the potential for employers to misuse the information with which they are entrusted by reaching unjustifiable recruitment decisions, but if the obligation of the state is to avoid arbitrary interferences with Article 8 rights, then one can see that the additional problem of plain breach of privacy is a significant issue for people such as Mrs. Gallagher. Applicants like Mrs. Gallagher ought not to suffer the indignity or the embarrassment of having to discuss their criminal history with prospective employers where that history is irrelevant to the employment sought. Accordingly, the following conclusions can be drawn from Mrs. Gallagher's experience. The multiple convictions rule has an exceptionally long reach. In temporal terms, both retrospectively and prospectively, the reach is limitless, and it attaches regardless of the nature of the offence, disposal, or the passage of time. Crucially, at the time of her interaction with the scheme in 2014, the appellant denied the respondent, the appellant's scheme, I should say more properly, denied the respondent any opportunity of assessment of relevance having regard to the post she applied for. In real terms, she cannot apply to come out of the obligations of the system, having regard to the continuing effect of, in particular, the 1979 order, the Rehabilitation of Offenders Order. Secondly, the scheme compromises the ability of those like Mrs. Gallagher with minor criminal history to move on with their lives and to put their past behind them. It requires from them embarrassing exchanges with employers, has the potential to impact on employment generally, and may have a chilling effect. It has the potential, at the very least, to undermine the public interest in rehabilitation. This leads me to the following question. Is it really the case, as the appellant seems to suggest, that because they have introduced a scheme with some nuance or discrimination, because the rules might generally get it right, that the irrelevant disclosures are something that that is Mrs. Gallagher, just has to put up with? In the appellant's stated case, they refer to Steck against the United Kingdom at paragraph 108. This is at MS 8139. in support of the view that not only are bright lines unobjectionable, but in the particular context of this case, a wide margin of appreciation is necessary when we approach to analyse the issue of necessity. We say that that is the wrong approach. We say, as it was said in the Court of Appeal in T, that a bright line can't be defended if it fails in a significant way to achieve its purpose or is disproportionate. This is not a situation having regard to the nature of the interference where a wide margin is appropriate. We say also that a significant interference with Article 8 rights demands a solution for the reasons outlined by my learned friend, Mr. Southey. There are various options, as he helpfully outlined. In our written case, from paragraphs 120 to 135, we highlight the Department's introduction of an independent review mechanism. We resist the temptation to suggest that the decision to introduce this mechanism inevitably reflects a prior incompatibility. It is accepted that the compatibility of the scheme, absent a review mechanism, has to be assessed on its own merits. We refer to the review mechanism, however, for several reasons. Firstly, to illustrate that it is perfectly possible, indeed easy, to adopt the language of Mr. Southey, to provide a workable mechanism by which interferences with Article 8 rights in this context can be effectively scrutinised before serious harm is caused to the likes of Mrs. Gallagher. And we say that this can be done without undermining the legitimate aim of safeguarding vulnerable people. Secondly, our reference to the review mechanism demonstrates that the preoccupation with the central role of the employer is not inevitable or even necessary. Thirdly, reference to the review helps to illustrate that in Northern Ireland, at least, looking across the scheme as a whole, hard cases are not numerically small, but equally that the review mechanism has not been avalanched or overwhelmed by excessive numbers, which, as I understand it, as part of the English appeals, if I can put it in those terms, was advanced as an objection. The statutory provisions which gave birth to the review mechanism were I think, opened to the court briefly yesterday. I don't intend, unless the court would find it particularly helpful, to do that again. I will nevertheless draw your attention, and you can pick up on it, draw your attention to sections 5.5 and 6.7 of Schedule 8A, which can be found within tab 32. And the specific point I would invite my lady and your lordships to look at is what might be referred to as the safeguarding lock. In other words, the independent reviewer cannot review information, cannot remove information from a certificate unless satisfied that it would not undermine the safeguarding of vulnerable people.
Yes, we saw that yesterday.
At paragraph 115 of the appellant's case, which can be found at 8141 of CORE, it stated that the existence of the limited review process, which has now been introduced, should not be seen as a necessary requirement in order for the remaining aspects of the scheme to be lawful under both limbs of Article 8.2. Despite the appellant's efforts to diminish the significance of the review mechanism, it is clear that the Department always planned that its model would embrace such a framework. As part of the legislative process in Northern Ireland, it is necessary for the Department to bring its plans for legislation before the Scrutiny Committee, in this case the Justice Committee. And if I could ask your Lordships to go to the CORE volume, not the CORE Authorities volume, but the CORE volume, and pull up MS 8506. I should say, just to orientate ourselves, the starting page is at 8500, that's MS 8500. And this is a document prepared by the Department 6 months before the implementation of the more calibrated scheme with which we are concerned, and reflected at 8502 of the document, which was intended for briefing purposes with the Justice Committee. You will find at paragraph 6 reference to the advice received by the Department on the risk of challenge to the current regime. And they say, as a result, we, that is the Department, believe that there is a real prospect of a finding of a violation of Article 8 if some of the more fundamental specific shortcomings identified by the European Court are not addressed by change. Later then in the document at paragraph 18 at 8506, attention turns to the review mechanism. And it said, on the basis of legal advice, it is clear that there needs to be some provision for a person to ask for discretion to be exercised in their particular case, and that the absence of a review mechanism might render a scheme as a whole disproportionate. The Minister agrees that there should be a review process, and officials are currently working on developing this. Further advice will be submitted to the committee.
This is October 2013, isn't
Yes.
it? It's written while T was between the Court of Appeal and this court.
That's right, and I suspect it was written bearing in mind the lessons to be drawn from the Court of Appeal.
Yeah.
And as I say, it's 6 months before Northern Ireland was lagging behind the more calibrated scheme that had been introduced in this jurisdiction in 2013. We were lagging behind by something in the order of 12 months. And for example, the multiple conviction rule came into effect then in April 2014, but crucially absent the review mechanism, and therefore when Mrs. Gallagher was required to, if you like, participate in the scheme, she had no review mechanism to turn to. If I could ask you then just to bear with me with this bundle and turn to 8515. And will see that this is a paper prepared by the then Minister of Justice, Mr. Ford, to ministers of the Northern Ireland Executive, and he is setting out here in November 2013, again 5 or 6 months prior to the introduction of the more calibrated scheme. He's setting out in this document, you can see over the page 8516, why filtering is necessary, the issue about Article 8 and its potential violation, and then we get to paragraph 12 at 8519, and in much the same way as the Justice Committee has been briefed in terms of the importance of a review process at paragraph 12, somewhat obliquely reference is made to that. The provision of a review process would require amendment to the Police Act 1997, and this would need primary legislation. That in part, my lady and my lords, explains the delay in putting this into operation. This would be taken forward as part of the changes being made to the criminal record system in the forthcoming Justice Bill. And then in an annex to this document at 8523, again taking up the theme of the review mechanism, while the scheme will have a statutory basis and set out well-defined criteria for filtering, it is clear from legal advice that additionally there needs to be some provision for a person to ask for discretion to be exercised in their particular case, for example, where despite the correct application of the criteria, a person may still believe the information disclosed is disproportionate. The absence of such a review mechanism might render a scheme as a whole as disproportionate. It is therefore felt that there should be a review process, and officials are currently working on developing this. In essence, my lady and my lords, the Minister was endorsing the view that the Executive should understand the importance of a review mechanism, and it might fairly be inferred that the Executive was granting its approval for amending legislation to provide for such a review mechanism. This issue was the subject of comment in the Court of Appeal, which I will turn to. But in essence, the point comes to this. The views expressed to the Justice Committee and to the Minister, in my respectful submission, amounts to a candid admission at a date prior to the introduction of the scheme that the Department was aware that the broad brush effect, even of its more nuanced scheme, including the multiple conviction rule, could produce outcomes which might be regarded as disproportionate. The Minister's words seem to capture the problem which the appellant respectfully would now seek to deny. The independent review mechanism came into effect in 2016. Guidance has been published more recently in June 2017 to assist the reviewer with his work. It is to be found in volume 13 of the authorities at tab 134. I wish, with your indulgence, just to briefly refer to a number of particular aspects of it.
MS 4814 it starts.
It does, MS 4814. And The guidance to the independent reviewer sets out a number of key principles which must inform his work. You can see, my lords and my lady, at paragraph 8 at 4817, the principles to be applied. In deciding whether to remove or retain criminal record information in any case, the reviewer should apply the following principles. And reflecting the statutory provisions which I alluded to earlier, principle 1 is the safeguarding lock.
I think Mr. Cole took us through this, didn't he?
We went through all this yesterday. At least I did.
Well, I think
What's the point you want to make?
What I wanted to highlight to you later is that the principles set out in this document emphasize that the ease with which a mechanism can be developed to integrate all of the key discriminators without diminishing the key legitimate aim of safeguarding. Moreover, where, for example, Principle 2 highlights the issue of relevance, it can clearly be seen that the importance which the appellant seeks to give to the role of the employer is simply unnecessary. In terms of relevance, I would also emphasize that while much has been said about the multiple conviction rule and how it might inform issues such as pattern of offending or propensity or recklessness, submissions with which we disagree. But even if that is held to be true, there is another part of the sentence to be written in. Relevance is important in terms of safeguarding and suitability. So whereas it might be suggested that multiple convictions can give rise to the establishment of a pattern, the principle 2 set out here would suggest that that is not enough. Relevance, as it says here, is in the sense that non-disclosure would not undermine the safeguarding of vulnerable groups or pose a risk of harm to the public. Finally, my lords, can I refer you to the annual report of the independent reviewer? It can be found in the same volume, volume 13, at tab 138. And again, I know that you touched on this yesterday. I think this point might just bear repeating, and it's the question of the statistics. You will find the number of cases reviewed by the independent reviewer in the first year of his work set out at 4931. and you will be conscious that there is two routes by which reviews can come before the reviewer. All convictions or cautions acquired by a person under the age of 18 will come automatically to the reviewer where a certificate falls to be issued, and all other cases require an application. So you can see in the statistics at 4931 that the vast majority of cases come via the automatic route, and you can see that the numbers 309 out of 395 have had information removed. That is 78.2%, if my GCSE maths is accurate.
And the automatic referrals are where the conviction was sustained under 18, is that right?
The automatic referrals, that's right, yeah.
Yeah.
At
Page 493 something.
and what the reviewer calls the appeals, which is, if you like, the adult convictions, if I use that term advisedly, the 55 out of 61 where information was removed amounts to just over 90%. And what the independent reviewer says about this is worthy of some attention. He says at 4932 that auto referrals, as he calls them, represent the largest category of referrals. In many cases, the information removed has related to minor offences from a number of years ago, where the applicant has not offended in the interim period, and I have felt that the information is no longer relevant to the specific role applied for. In those cases, I may have also considered that the presence of the information is likely to have a disproportionate impact on the person who is seeking to work with the vulnerable. Where I have retained the information, I have considered the gravity of the offence, its currency, and the impact of the disclosure on the applicant, or of non-disclosure on the vulnerable people the process is designed to protect. So you can see perfectly sensibly the reviewer is engaging with the kinds of discriminators that the jurisprudence have identified as being key to establishing suitability, and without need to refer to the employer, he is carrying out that balancing exercise. As my learned friend Mr. Southey has outlined in greater detail than I need do, there are a range of options which could be conceived of to address the issues posed by cases such as Gallagher. This review mechanism is by no means perfect. I've already alluded to the fact that there is an incongruity which arises from the failure on the part of the department to bring the self-disclosure element of the scheme within the mechanism. There are other issues of practicality in that you raise your appeal or be the subject of automatic referral to the independent assessor only at the point when a certificate becomes live. So in practical terms, the court will appreciate that the need to repeat that exercise rather than have a more automatic approach where you can preempt the application for employment might be considered to be a better way forward. Those issues, of course, don't arise directly for consideration by the court. What we say in summary is that having regard to the interference with Article 8 rights experienced by Mrs. Gallagher, a review mechanism of the type which I've just outlined marks a stepped progression which helps to bring the system, at least in part, towards where it needs to be.
That's the highest you'd put it.
I think that's as quite begrudging, perhaps, but that's as high as we can put it.
Yes.
The key problem, I must emphasise, is that in the normal way of applying for employment, you complete your application form, and as part and parcel of that, you complete your pro forma for self-declaration. So the employer is possessed of your criminal antecedents in any event. Really, one can see that the review mechanism adopts many, if not all, of the right principles. It just isn't broad enough to cater for that key problem. My lady and my lords, those are my submissions. 3 o'clock, I think.
You're in time.
In time. I'm
Yes,
obliged.
indeed.
Mr.
Well
Paul
done.
set a good example.
Thank you very much indeed, Mr. Wolfe. Yes. Does your learned junior wish to follow? I thought not, no. Mr. Owen.
My lady and my lords, Mr. Southey has shouldered the main burden on behalf of the English and Welsh respondents, and I gratefully adopt all he said on the common issues of law. Our case was drafted in full knowledge that the court would have 4 separate respondents' submissions, and with a view to avoiding what we call tedious repetition, we sought to add value by focusing on the discrete position of convictions acquired in childhood against the background of what we submit are a number of relevant international instruments. Relevant in this appeal because, as Lord Reid said in T, I'll give you the reference, it's paragraph 134 at MS 900, they are consistent in their emphasis on the importance attached to the rehabilitation of minor and juvenile offenders and to the confidentiality of their criminal records as an aid to promoting their rehabilitation. Thank you. Listening to my learned friend Sir James's submissions yesterday, one might have thought that the system of disclosing on a lifelong, mandatory, unreviewable basis a very wide range of criminal records acquired in childhood has nothing whatsoever to do with the youth justice system, on the basis that the relevant principles which establish discrete obligations towards the welfare of children and their rehabilitation are confined to the way that children are dealt with directly in the process of arrest, charge, trial, and sentence. And we say that's wrong. How childhood convictions and cautions are dealt with by the state in later life, in most cases, inevitably, after the child has become an adult, are intimately linked to a central goal of the youth justice system as a whole, namely the principle of effective rehabilitation. And so, put shortly, the way in which the disclosure system functions determines the extent to which people are tied forever to their childhood contact with the criminal justice system. And in that way, it is directly related to the prospect of effective rehabilitation and reintegration into society. Of course, it is the case that where a childhood conviction or caution is in fact relevant to public protection, then it may legitimately be disclosed. But G's case, and W's also, because his conviction was as a child as well, demonstrates, we submit, a structural failure in terms of the absence of a discrete approach to childhood criminal records. Our case is supplemented by the written submissions of the two interveners, Unlock, whose submissions are at MS 6074, and Clan Child Law from Scotland, that's supplementary memory stick 61, both of whom have unrivaled experience of advising on the consequences of the disclosure regime, both here in England and Wales in the case of Unlock, and Scotland in the case of Clan. And I, of course, adopt those submissions, particularly those by Unlock, insofar as they powerfully expose the harsh consequences of the current disclosure scheme in England and Wales in the way it deals with childhood convictions and cautions as a result of the application of the two bright line rules in play in these appeals. The intervention from Clan Scotland explains, and that's between paragraphs 20 and 25, supplementary memory stick 67 to 69, the radically different approach taken in Scotland in response to the ruling in 2017 in the case of P against Scottish ministers. I'll come to that authority perhaps at the end, where I'm also going to hand up a note which shows how G's conduct and his caution would be treated now in Northern Ireland and in Scotland. But just for your note, a P case is volume 6, tab 65, MS 2283. In Scotland, G's caution as a child would not result in a mandatory lifelong unreviewable obligation of disclosure, and nor would it in Northern Ireland. In his submissions yesterday, Sir James rejected all our criticisms of the England and Wales scheme. He was anxious both to emphasise that the scheme as drafted was based on adequate consideration of all relevant law governing the treatment of children. He cited various references from, for example, Ms. Sunita Mason's reports on the basis that they showed she was aware of and took into account the need to treat childhood records differently from adult records. But at the same time, he appeared to dismiss the idea that there were any binding relevant international law principles in the field of a disclosure scheme, such as the one under consideration in these appeals, because any such principles are only relevant to the actual treatment of children in the formal justice system itself, arrest, charge, trial, and sentence. And he certainly, you may think, given the impression that in this field there are few, if any, firm child-specific principles which provide a solid basis for legal review. And we say, with respect, that he's wrong on both counts. Although the Secretary of State's case invited this court to provide further guidance to the Secretary of State should the appeals be dismissed, it isn't clear, we would suggest from his submissions, whether he accepts there is anything to be gleaned from international law principles governing the treatment of children in the criminal justice system. Neither in the evidence lodged by the Secretaries of State, nor Mrs. Mason's reports, nor any of the citations from the affirmative resolution procedure in Mrs. Foles's evidence, nor the Secretary of State's printed case, is there considered reference to any of the relevant principles of law identified in the judgments of Lord Wilson and Lord Reid, in the context, as T's case was, of the disclosure of a childhood conviction, in fact, 2 convictions. And we say with respect that not only was there no reference to those principles, there was therefore no explanation of how the revised scheme is compatible with such principles. T, it must be remembered, concerned 2 warnings for stealing bikes issued when he was aged 11. Like G, T had no other criminal record at the relevant time, and the court specifically addressed the question of how the mandatory disclosure of T's convictions could be reconciled with a number of international law instruments designed to promote a child's reintegration and the child assuming a constructive role in societies. T's warnings would not now be subject to mandatory disclosure under the multiple convictions rule because they are warnings. But had they resulted in convictions rather than warnings, they would be required to be disclosed forever under the revised scheme. I think Mr. Southey made that point. And we do submit that the idea that Lord Wilson and Lord Reid would have regarded it as compatible with Article 8, mandatorily to disclose on a lifelong basis T's 2 convictions for theft as opposed to his warnings, is frankly difficult to believe. Yet that is the logic of Malone and Friends' submissions in circumstances where 2 convictions for stealing a bike at the age of 11 would be liable to lifelong, mandatory, unreviewable disclosure under the new scheme. Just as G's conviction, or caution rather, for what was assessed at the time to be consensual sexual experimentation with 2 boys in his peer group when he was aged 11 and 12, is now treated under the serious offence rule. We say that a striking feature of the current criminal records regime is that although England and Wales has a separate youth justice system and has, as we'll see from some reports that I'll show you extracts from, that system has in recent years achieved a huge shift in the numbers of children and young people who become enmeshed in the formal criminal justice system. Both childhood and adult criminal records are dealt with under a single legal regime with filtering rules of universal application, save in one respect, that minor ancient convictions in relation to persons under 18 are filtered sooner. And so, apart from the fact that the scheme provides for that shorter rehabilitation period for under 18 minor convictions, the filtering rules make no distinction between adult and childhood records. This, we say, striking failure to construct a disclosure scheme that makes different provision as between childhood and adult offending has been the source of almost universal condemnation by those involved in the youth justice system. I'll give you references to a number of those reports which are in the bundles, but can I start with the Charlie Taylor Review, which is volume 14 at tab 149, MS 5200. You'll see that this is a review of the youth justice system in England and Wales. It was commissioned by the Ministry of Justice and published in December 2016. Mr. Taylor has been the chair of the Youth Justice Board since March 2017. So when he prepared the report, he wasn't in fact chair of the board, but he had previously been the chief executive of the National College of Teaching and Leadership, and he's a former head teacher at a school called the Willows, which is a school for children with complex behavioural, emotional and social difficulties. And he was a government advisor to the coalition government on behaviour in schools. Can we start I'll just draw your attention to a few passages in the report. MS 5204, he begins with a context and he refers back to the fact that in 2007, and G was cautioned in 2006, 225,000 children in England and Wales received a caution or conviction for a notifiable offence. Of these, 106,000 were first-time entrants to the system, 126,000 prosecuted at court, and so on. Since that high watermark, the number of children dealt with by the youth justice system has reduced spectacularly, with consistent year-on-year falls. The number of children cautioned and convicted in 2015 was 47,000, so it's down 79% since 2007. And over the same period, the number of children entering the youth justice system for the first time has fallen by 82%. The number prosecuted at court is reduced by 69%. And he makes the observation that the demand for youth justice services has changed. The police and youth offending services have rightly increasingly sought to deal informally with minor offending by children. That diversion from the youth justice system of children who are never likely to continue offending has meant that those who remain are the most difficult to rehabilitate. Now, the relevance of that is that it will be the case that for the next 40 to 50, perhaps 60 years, there will be a cohort of adults who will have been dealt with under that old system, if we call it that, which resulted in a massively greater resort to the formal criminal justice system in the form of cautions or convictions. And so to the extent that the current filtering rules will impact on that cohort via the multiple conviction rule as well as the serious offence rule, this is a problem of potentially massive scale. It's impossible, obviously, to know precisely, but one can see how the long-term effect of this current scheme will impact in the context of what was a very different approach to youth criminal justice. Over the page...
It was about a decade, wasn't it?
Yes, yes.
From about 1997
yes,
until 2007.
It was the Crime and Disorder Act 1998,
right.
which brought in a new scheme. And in fact, my lady was in the case of Durham Constabulary looking at the compatibility of the new approach with international convention principles. Yeah. So just over the page, principles and aims for the review. Just draw your attention to paragraph 6, where Mr. Taylor sets out precisely why it is one has to approach offending in childhood differently from adulthood. The perhaps obvious points, but points that are important to make. And the same in paragraph 9 on 5206. In reforming the youth justice system, it must be recognised for the vast majority of children, offending is a short-lived phase. At 5227, MS 5227, section paragraph 82, in the context of his review of the youth justice system, Mr. Taylor looks at the need for a reformed criminal record system for children. But I invite the court, it may be helpful for you to read that section now, and I'll just make a couple of points. So that the whole section we say is a valuable, make valuable points. Para 85 in particular, and a central point about our case is that the current system lacks a distinct and considered approach to childhood offending. And he then goes on to deal with alternative methods. I appreciate the court is not itself going to draft an alternative scheme, but insofar as it is an issue as to what different approaches could be taken, the Taylor Review suggests a particular approach to childhood offending, the operation of a presumption against the disclosure of childhood convictions and cautions unless relevant.
Well, 88's interesting, isn't it?
Yes,
Once spent, should quickly become non-disclosable,
yes,
with the exception of the most serious offences,
yes,
which begs the question of how on earth one
yes.
one categorises those. Particularly, I suppose, there's likely to be a problem with at least the description
Yes.
of sexual offences.
Well, indeed, and of course I make the point that I've never suggested that the entire idea of a principle of drawing up a list of offences is itself incompatible. The point we make in G's case is that the label you attach to an offence can be strikingly at odds with the true seriousness of the conduct.
Absolutely.
As it was assessed.
As it was, and as the rider attached to the certificate made clear.
Indeed, and I'll come to that later. But the approach that Mr. Taylor is suggesting is a presumption against disclosure, absent relevance and justification. And that, in our submission, would be an obvious solution to what we say is the flaw in the current system, which treats childhood convictions of all kinds in the same way as an adult conviction. In other words, in the application of the filtering rules.
But does that mean an individual consideration of each one? Presumably it does it?
Yes, it would. It would have to be that. And it's my submission that a bright line rule in this area is inherently inimical to the positive obligation of effective rehabilitation of each individual child. Whatever the merits of bright line rules might be, in the context of a positive duty to promote rehabilitation, then a bright line rule which treats childhood convictions in precisely the same way as adult convictions is incompatible with international law principles, Convention on the Rights of the Child, and in turn then Article 8, insofar as that's relevant to Article 8. Mr. Taylor's recommendations are summarised at page 5254, MS 5254, and he calibrates it into behaviour of under 15s and 15 to 17s. And again, of course, it's just another point of view. I accept that. But the central point is the need for a discrete approach to childhood offending.
What has been the official reaction to this?
My solicitor has put together, I was going to read this to you at the end, of where we are in all the different reviews. In short, everything's parked until you give judgment.
Thank you very much.
So, with that...
no pressure there.
No pressure at all, no. End of July will be fine. My lady, my lords, with that introduction, can I just make 4 core points about G's case? Number 1, the facts of his case demonstrate that a diversionary measure was imposed in relation to childhood behaviour, which, as we'll see, the Surrey Police Disclosure Officer concluded was not indicative of any relevant public safety risk, but which is covered by the non-filterable list. So diversionary measure imposed, not indicative of risk. And I've made the point that, bearing in mind the dramatic change in the approach to dealing with childhood offending over the last decade, it is obvious there must be many thousands of people in a similar position to G, affected by the 2 rules. Number 2, whether in relation to diversionary measures such as a caution or in relation to convictions acquired in childhood, the current scheme lacks, as Mr. Taylor has observed, a distinct and considered approach to childhood offending. 3, I've made this point, but just so it's clear, in maintaining a set of bright line rules which apply inflexibly to certain categories of offences without regard to them having occurred in childhood. The England and Wales scheme is not merely more punitive than any other criminal record scheme in comparable countries, and I'll show you what the Standing Committee on Youth Justice has said about that. It also operates so as to frustrate a fundamental requirement of international law, namely effective rehabilitation of children caught up in the system. So that's my point, that a bright line rule is inimical to the individual duty to promote rehabilitation. And fourthly, there are obviously, as you are now aware, alternative schemes which could provide for review on an individual basis in relation to childhood convictions based on relevance and proportionality. See Northern Ireland, see Scotland, see the Section 113B scheme, which, as we'll see, the National Police Chiefs Council has identified as the way in which fairness, relevance and proportionality could be brought into a scheme for disclosure of childhood convictions and cautions. And so we say it isn't rocket science, and nor would it be an added burden financially, as the scheme is self-financing. Could I just show you volume 15, tab 152, which is MS 5353. This is a briefing by Unlock. So, 152. On MS 5353, it's the section on discretionary filtering, and the passage at the bottom says the Home Office would need to undertake an assessment of the costs of introducing a discretionary filtering process, which it has yet to do. The current DBS system is itself financing by employers. In addition to the fixed fee charged by the DBS, employers pay, and so on, sets out the pricing. And at the end it says, at the end of financial year 2017, the DBS was sitting on approximately £70 million cash balance. Better not tell the Chancellor. But the point is the scheme is self-financing. And so to the extent that it had to be expanded or changed, the funding would be provided. Before I refer you to the numerous reports which condemn the current scheme insofar as it fails to address childhood convictions separately from adult criminal convictions, can I just draw your attention to the relevant international and indeed domestic law provisions which are relevant to...
Can I just go back to the self-financing bit, Mr.
Yes.
Rain? It sounds wonderful. But the bodies which need to ask for certificates are, by and large, listed, particularly enhanced certificates, are listed in the legislation, aren't they?
Do you mean the ones that are registered?
Yes. Well, no, what I mean is that the circumstances in which someone needs to ask for an ECRC are prescribed, aren't they, in the legislation?
Yes.
So what it amounts to is that it's a levy on employers.
Well,
It may well be self-financing in the sense that it isn't coming out of taxed
yes. Well,
taxation.
That's what he meant.
That's what you meant.
That's what I meant.
All right.
Well, it says here, self-financing by employers.
By employers, yes.
Yes, but by employers who have no choice.
Well, yes.
Okay.
But it's not, as my Lord Kharmouth said, if the law requires matters to be done, they have to be done.
Yes,
it's perhaps not my best point, but it's part of the picture as a whole.
I think you can at least say we shouldn't make any assumptions about
Yes.
the enormous financial...
Yes, the image that Mr. Eadie has presented is both a practical one of how on earth would you go about it in a different way, and the sheer administrative and burden that it will place on the state to achieve it. So it's in that context. International law principles, our case, I won't take you to it, but just for your note, we deal with the relevant international law principles between paragraphs 25 and 38, MS 5992 to 6000. Unlock, adopt and develop our submissions at paragraphs 2.1 to 2.15 of their written case. That's MS 6077 to 6083. There are two authorities I do want to show you. Just very brief bits that you haven't looked at yet in relation to the relevant instruments. Could I start with Durham Constabulary, which is Volume 2, Tab 19. MS 794. Can I just explain? I'm taking you to this for two purposes. Firstly, to show how, in that case, relevant principles of international child law were deployed to test the compatibility of the scheme with convention rights. And secondly, it's revealing about the nature and purpose of imposing a caution on a child in the first place. Because that, we submit, is relevant to the proportionality of a scheme, which then years later or forever requires the child to disclose the caution that was imposed for diversionary purposes. So the principal issue in the case, in the context of a warning being administered under the new procedure in the Crime and Disorder Act without the consent of the stepfather, was compatible with fundamental rights, convention rights, and in particular was compatible with Article 6. And so the real issue was the imposition of the reprimand or the warning in breach of Article 6 on fair trial grounds. And Lord Bingham deals with this, two passages. Paragraph 14 at 804. He begins in paragraph 14 by saying it was contended that the giving and recording of a warning in effect established R's guilt of what was alleged against him. Of course, true, a person who admits commission of an offence without any inducement or pressure to do so would ordinarily be assumed to have committed it. There was here no suggestion of inducement. But the determination of a criminal charge to be properly so regarded must expose the subject of the charge to the possibility of punishment, whether in the event punishment is imposed or not, a process which can only culminate in measures of a preventative, curative, rehabilitative, or welfare-promoting kind will not ordinarily be the determination of a criminal charge. And so that's why Article 6 doesn't apply to the process. It's because you're giving the child the caution for welfare rehabilitative purposes. And over the page, I won't take you to it, but there's a quote from Lord Roger in a Scottish case to similar effect. Page 806, MS 806, you see at the end, having quoted from Lord Roger, Lord Bingham said, Lord Penrose and Lord McFadden similarly concluded that the proceedings did not involve the determination of a criminal charge, since they were not of a penal character, but designed to promote the welfare of the child. And so, at 19, Lord Bingham says, for the reasons I've given, I'm clear opinion, neither the warning of R nor the decision to warn him involved the determination of a criminal charge against him. Had they done so, there would have been no valid waiver by him of his fair trial rights and so on. And nor was there a breach of spirit or letter of the Convention on the Rights of the Child. Section 65 and 66 of the 98 Act were not establishing a system of criminal trial and punishment. They were aiming to keep first-time offenders like R out of court, while seeking to prevent future offending in their own interest and that of society. They involve no breach of Article 6. My lady, Baroness Hale, on MS 809, I won't read it all out, but I invite the court to read the whole of the speech, of the judgment. Well, it's the speech.
It's a speech.
Yes. But what is clear from my lady's analysis is the relevance of a number of international law and domestic law principles, beginning with Section 44 of the 1933 Act, and then looking at the UN rules, Beijing rules, and then over the page, one sees at 26, Beijing rules are not binding on member states, but the same principles reflected in the Convention. This is not only binding in international, it's reflected in the interpretation and application by the Court of Human Rights, see Venables v. against the United Kingdom. Then reference to other provisions from the Convention, 37, 40, and so on. At paragraph 29, my lady observes that there can be no doubt, therefore, that constructive diversion policies and practices are thoroughly consistent with the fundamental principles of those international instruments. And then my lady turns at 39 to consider the question of whether the lack of a requirement for the consent of either the child or the parent is compatible on the basis that it was a striking and therefore deliberate decision. And after perhaps, I think, fairly saying that my lady agonized about whether the scheme was compatible, ultimately concluded at 49, not without considerable misgivings, because of the potentially serious effects upon the child's future, reached the conclusion this aspect of the scheme is compatible. So, the Durham establishes two points I sought to make: relevance of international law principles concerning the treatment of the child in the criminal justice system, and therefore relevant to the review of any scheme which impacts on childhood engagement with the criminal justice system, and fundamentally the purpose of a caution or reprimand or warning in the first place in the context of a scheme which, far from assisting his rehabilitation, now means that someone in G's position who got a caution for a very, on the face of it, serious offence. Why did he get a caution? It's because it wasn't regarded as very serious. And the purpose of imposing it was to assist his rehabilitation or improve his behaviour and whatever, but certainly not, I would suggest, in the context where Article 6 doesn't apply, to enable it to remain on his record forever and liable to mandatory lifelong unreviewable disclosure. In T, Core Volume 3, Tab 21, two passages which have not been looked at. Lord Wilson, so that's MS 875, Core Volume 3, Tab 21, MS 875. In paragraph 41, in the context of his review of necessity, one sees at G on that page, the case of T is held up as an egregious example of the flaws in the regime. His theft of 2 bicycles before he even became a teenager, that's the same for G. His conduct was when he was 11 and 12, was disclosed in connection with his proposed participation in sporting activities with children, to which it is said it had no conceivable relevance. Indeed, entries reflective of childish error should be a particular candidate for total elimination in the interest, in the words of Article 40 of the Convention, of promoting the child's reintegration and the child assuming a constructive role in society. Lord Reid deals with the relevance of the international instruments between paragraphs 128 and 134, MS 899 and following. I don't invite you to read it now, but just draw your attention to it. It is in many ways very similar to my lady's summary of the principles from the Durham case. And one sees at 134, the passage I quoted at the beginning, some of the instruments are of greater significance than others, but they're consistent in the emphasis on the importance attached to the rehabilitation of minor and juvenile offenders and the confidentiality of their criminal records. That a person should in practice be required throughout his adult life to disclose the fact that he committed a minor offence as juvenile if he wishes to pursue a wide range of careers is difficult to reconcile with these provisions in the absence of what Recommendation 10 of Recommendation R8720 describes as compelling compelling grounds. Going back to the point that my Lord Hughes made earlier on, Lord Reid there refers to a minor offence, but in my submission, the context of a child who is convicted of, on the face of it, a serious offence, but only gets a caution because it isn't regarded as a serious offence, there's no logic in treating that differently in terms of the impact of international law principles, and in particular the general duty to rehabilitate, to assist or promote, to have a scheme in place which assists rather than frustrates the process of rehabilitation. To similar effect, in our case, I'm not going to take you to them because it may be thought they add nothing more, but there are two Strasbourg decisions on this point. We've referred to them in paragraphs 33 and 34 of our case. One is the case of Neulinger against Switzerland. In fact, that's not in the bundle, but we've summarised its relevant principle in paragraph 33. And then Maslow against Austria, volume 11, tab 109, MS 4105. Again, we've summarised its import in paragraph 34 of the case. I'm not going to take you to it. And it's precisely because of the clear principles of international law that emerge from the rulings in Durham and T and the Strasbourg case law that the assessment of the current scheme by, I would say, all informed observers has been universally critical. I've already shown you the Taylor Review. Could I show you the National Police Chiefs Council evidence to the Justice Select Committee? It's volume 14, tab 144, MS 5037.
Just give me that electronic number.
Yes, volume 14, tab 144, MS 5037.
Thank you.
It's a short document, mercifully short, but it's, we submit, highly illuminating. The date is December 2016. As you'll see, it's written evidence from the National Police Chiefs Council Disclosure and Safeguarding Portfolio. It's submitted by the Assistant Chief Constable of Hampshire in his capacity as the lead for disclosure and safeguarding. He sets out in 1.2 that the submission is in respect of the call for evidence from the Justice Select Committee. That's the House of Commons Justice, not Justice, the NGO, in relation to the offences committed by people under 18, and sets out their terms of reference. Background we can skip over. It's really the issues. Could I just invite the court to read from 3.2, perhaps 3.1 to the end?
The end of 3?
No, sorry, to the end of the document, to 4.8.
Obviously predicting a rather large number of people reaching the age of 100.
Really, yeah.
Yeah. But you see, so the people most directly involved, certainly in the operation of the 113B system, the soft intelligence review, are effectively saying in relation to childhood convictions and cautions, so spent convictions and cautions, they can adopt the same approach. And as we'll see when we come to G's case, I'm just going to show you a couple of documents that were generated in his case by the Surrey disclosure officer. You see the kind of individualized review and checking that can be done. And so we submit that's an important indication of the practicality of introducing such a scheme for childhood convictions. Over the page, the next document is also from the National Police, that's 5041. This is submitted by another wing of the National Police Chiefs Council on policing. And she makes the point, Miss Adams and Miss Pinkney make the point at 2.2 that the portfolio is concerned by unnecessary criminalisation of young people. We have a national strategy for policing of children and young people, refers to the 82% reduction. But then at 3.1 says, historically 82% more young people were entered into the criminal justice system. Those young people have a conviction, and this may well be causing them problems as they move into adulthood. They can apply to the individual chief constable if they feel that the conviction was not appropriate. My suspicion is that not many young people do this. Therefore, there are many young people who previously received a disposal, which if they were a young person today committing the same offence, they would not receive. And that's the change in policing policy and so on. And then goes on to suggest alternative. That reference to you can apply to the Chief Constable to remove it is a reference to the exceptional cases policy that was introduced after the Humberside case changed the law on the retention of cautions and convictions. There was a procedure whereby you could apply, and Gede tried this, which is what led to the judicial review claim against the Chief Constable of Surrey, tried to get his caution deleted. But the criteria for removing a caution are very strict. In effect, it was inappropriately given, you were innocent of the offence and so on. So it's a very strict policy, and G was unable to succeed in that, which led to the officer attempting to do his best to contextualise the offence in circumstances where he had no discretion to delete it. The next document, again, I'll need to speed up in order to complete my submissions by 4, is the Standing Committee for Youth Justice, tab 146, MS, it's the next one along, MS 5043. This is dated March 2016. You see at 5045 the list of expert advisors who the Standing Committee drew their assistance from. You'll see at 5047, I'll just highlight a few of the comments. This report examines how childhood criminal records are treated in 16 jurisdictions. Of all the areas we looked at, the system in England and Wales is one of the most punitive. A criminal record acquired by a child in England and Wales can affect that person for longer and more profoundly than in any other jurisdiction under consideration, and then sets out the factors why that applies. At 5073 to 5080, the report looks at the England and Wales scheme in the context of many other schemes. And then at 5157 is the conclusion of the report. And having looked at all the various alternatives, they say that the treatment of childhood criminal records in England is the most punitive of all the jurisdictions examined. There's no distinction between child and adult records. Even minor records are retained and disclosed over lengthy periods. There's no provision for the sealing or expungement of records. The youth justice system operates in such a way that a sizable number of children acquire criminal records which have long-term implications. Almost 60,000 cautions and convictions attracting a criminal record were imposed on children in 2013-14 alone. And then they, over the page, the last few lines, the Standing Committee believes people need to be given a chance to leave the mistakes of childhood behind them. The current system does not allow this, tying thousands of people to childhood contact with the criminal justice system more tightly than in any of the other jurisdictions we have examined. At tab tab 148 is another report from the Standing Committee, Growing Up, Moving On, report on the Childhood Criminal Records Scheme, 5185 to 5186. You see the critique under the heading, What's Wrong with the Current System? An anchor to the past, no distinct system for children, no discretion, blanket disclosure. And at 5193 to 5194, recommendations, alternatives put forward for reform. Unlock have prepared a report. I'll just give you the reference. It's volume 14, tab 151, MS 5289, called A Life Sentence for Young People. And between 5296 and 5302 are a bewildering, at times, set of statistics which set out the sheer numbers of childhood records involved in terms of the numbers that have been dealt with under the previous and the current scheme. The next document is the Lamy Review. That's the review into black and minority ethnic people's engagement in the criminal justice system, prepared by Mr. Lamy, MP, at the request of the Prime Minister. His report is volume 13, tab 139, MS 4936, volume 13, tab 139, MS 4396.
4396.
Sorry, 4936 at 4964. He sets out his observations, which are in effect chiming with the Charlie Taylor review on the operation of the criminal records scheme on childhood convictions. Finally, in terms of the reports, can I just refer you in volume 13, tab 136, to the Justice Select Committee, not for its views on compatibility or its recommendations for reform, simply because the House of Commons Justice Committee's report contains references to the evidence which it received, and that's the only purpose for which I'm referring you to the committee's report, because it's a helpful recent distillation of views. This was published on the 27th of October last year. At 4847, the background to the inquiry is set out. They explain how evidence had been gathered by the previous committee before the election. The previous committee had done work in 2016 and reported, and then decided in October 2016 to launch an inquiry into the system governing the disclosure of youth criminal records and invited submissions. And it was in that context that the National Police Chiefs Council's material was sent. They say, paragraph 9, if I just draw your attention to the relevant paragraphs in which the evidence is summarised. Firstly, paragraph 9 at 4849. They simply refer to the overwhelming majority of evidence submitted to them containing the system needed to change in terms of childhood records. Paragraph 13, again, reference to the Youth Justice Board and the Children's Commissioner for England's evidence to them. Paragraph 52 on page 4863, the Law Commission's views on review of non-filterable offences is summarised and quoted, the Law Commission quoted, saying the system might be regarded as disproportionately harsh in its effect on young offenders. There's an argument that some offences, although they may justifiably be non-filterable when committed by an adult, should be allowed to be removed from the record after a time in the case of a young offender. Paragraphs 76 to 78 at 4870 to 4872 deal with some international comparisons. They specifically look at Germany, New Zealand, in comparison to England and Wales, and refer to the Standing Committee. And then at 4874, at paragraphs 87 to 88, they summarise evidence received on the operation of the filtering regime. And at 4876, paragraph 90 to 91, perhaps I could just show you paragraph 90 on 4876. Where the committee notes that a police-led system was proposed in 2011 by the former ACPO. That's also dealt with by the National Police Chief's evidence earlier on. I suppose it's really effectively recording that evidence. I don't think I need to read it again. And so in the face of what we submit is universal condemnation of the structural failure of the scheme to treat childhood records differently from adults, we say it was surprising that Malone and Friend suggested that the evidence supports the view that the current scheme is properly informed by an understanding of the relevant principles of law and practice. The citations that my learned friend made yesterday to Ms. Foles' evidence, to Ms. Mason's reports, and so on, if you look at them, and I'll just give you them again without taking you to them, given the time, but Ms. Foles' evidence is Appendix 2D, 1262 to 1278. That's memory stick 7385 and 7401. There's no mention in her evidence of any of the relevant international law principles. There's simply a reference to a principle agreed by the independent advisory panel to the effect that extra consideration should be given to convictions, cautions, warnings, and reprimands defined as minor received by individuals before their 18th birthday. So the only reference that's child-specific is to minor convictions, cautions, warnings, and reprimands before 18. Miss Mason's reports, a balanced approach and breaking the cycle. All that she does is refers on page 1299 of Appendix 2D, MS 7422, to two examples involving childhood records. And again, later in her report, there's a reference to the treatment of cautions for minor offences committed under 18. But her terms of reference, and the terms of reference are set out at memory stick 7506, does not include any reference to the relevant child law principles, or that she was approaching the scheme with those in mind. Can I just show you some documents?
It might be thought a little bit odd.
I'm sorry?
It might be thought a little bit odd, as Mrs. Mason was a family practitioner at the time.
There is one reference where she... can I just show you Appendix 2D, 1356? This is, that's memory stick 7479. This is not a page I think my friend referred you to yesterday. You may have done, I may have just not noted it down. But this is the section where she's dealing with the filtering of old and minor convictions. And she's... You did you? I'm sorry, yes. So, yeah, my learned friend referred you to this page and the next page. But what we see in the second column, 1356, is she says, I'm encouraged that in breaking the cycle, the government has indicated that they will look at this area, and particularly in relation to juvenile convictions. And so she, it would seem, was anticipating that the question of juvenile convictions would be addressed by the government via the Breaking the Cycle paper. Breaking the Cycle was effectively looking at sentencing and the prison system and the operation of the prison system. And the relevant report and the government's response are to be found in volume 14 at tabs 141 and 142. There is no mention in those documents of the treatment of childhood criminal records. And so to the extent that Ms. Mason may have been anticipated that this would be addressed elsewhere, it wasn't. Can I just show you some of the documents which are relevant to the question that arose about, well, what about individualised checking? How does it actually operate in practice? Can we look at Appendix 2B, page 639? That's MS 6762. Appendix 2B, 639. This is the letter that Mr. Edwards, the Data Bureau Supervisor at Surrey, wrote to G when the request for an enhanced CRB check arose. And it's clear from this that even though the scheme was requiring the mandatory disclosure of his caution, nonetheless, Mr. Edwards had individually reviewed it. That must be the case because otherwise he wouldn't have come up with the text which he includes in that letter, which he was proposing to add to the certificate to contextualise it. And you see, he seems to have written two letters on the same day because there's a similar, slightly more detailed letter on page 642. And you'll see in the third paragraph, he says on 642, the purpose of the proposed disclosure is to try and place the information in context. The type of offence is such that the disclosure of the reprimands alone is likely to cause an employer more concern than perhaps they warrant. It's therefore our intention to attempt to present the information in a more balanced context in the hope that it will not adversely affect your application. And what happened subsequently, as you know from his account, is that he then applied under the exceptional case procedure to have the caution removed because for him, even revealing the nature of the offence for which he had been cautioned was so embarrassing that he was not willing to go through with the job application. His application to have the caution deleted failed for the reasons I've given about the strictness of the criteria, and he accordingly lost his job. It's clear from Mr. Edwards' internal explanations, he regarded the task that he was faced with as wholly disproportionate, or rather the disclosure that he was forced to make as wholly disproportionate. Could we look at Appendix Part 2C at 1081?
MS, please.
MS 7204. 7204. So this is an internal Surrey police document dated March 2012 from Mr. Edwards, who emerges as something of a heroic figure from these papers in terms of the care which he was clearly taking, but he was faced with the system as it was. And you see that he's writing to Ms. Woodall, the detective superintendent. This is the exceptional case application. You'll see the third paragraph, fourth paragraph. This was a rather unusual case, and the proposed disclosure regarding the enhanced CRB check essentially had the intention of assisting the applicant. Concerned the applicant was likely to have been informed at the time of the reprimand it would be deleted after a period of 5 years, no longer the case. Also concerned automatic disclosure, particularly in view of the nature of the offence, would likely cause an employer more concern than perhaps the circumstances actually warranted. And you see at 1084 to 1085, where this is the disclosure rationale audit trail, where Mr. Edwards carefully answers the questions in each box I won't read it now, but invite the court to read it in full. He says there, the information is not relevant. You see that in box 3. Do you believe the information to be relevant to considerations of risk that this individual may pose to children? Answer, no. And then he sets out why the extra disclosure will do the best to contextualize it. So we rely on that as an indication of how an individualised scheme could operate. It's quite clear in this case that if Mr. Edwards had been, the Surrey police had been able to, they wouldn't have disclosed G's caution, but the system mandated it. I see the time. I could finish quickly. There's one note I need to hand up. I'll be about 10 minutes.
Yes.
Keep sitting?
Keep sitting
Yes.
for as short a time as you can possibly make it.
Okay. Could I have the note, please? The hand up. Sorry, we didn't hand this up earlier. The purpose of this note is, I trust, self-explanatory. I don't need to read it. I can just invite the court to read it. It's an attempt to address the disclosure position of G's caution in the rest of the UK, and were he to apply to work abroad. And so it looks at how his caution would be treated under the Northern Ireland scheme, and Mr. Coll has been kind enough to agree that this note is accurate for the Northern Ireland scheme. Scotland, Clan Scotland, have assisted us in approving it from their perspective. They have in turn approached the Scottish officers, but of course I can't say they're not parties to the appeal and so on. But we thought it helpful to set out how the scheme, or how his caution would be treated, and the answer is it would not be disclosed without the opportunity of review. I needn't take you to it. I've given you the reference to the P case, P and the Scottish ministers, which, as Clan Child Law explains, demonstrates that in the face of the decision in P and Scottish ministers, which involved offending behaviour very similar to G, it was sexual behaviour as a 12-year-old child, resulting in the Scottish equivalent of a caution in the Scottish children's hearing system. And the conclusion was that the scheme in Scotland, which mandatorily required that to be disclosed on a lifelong basis, was incompatible with Article 8, reference to T, obviously. And instead of appealing the decision, the Scottish ministers amended the scheme to produce the scheme that is then set out in that note, which would mean that a person in G's position would not be required to disclose or have it disclosed forever without the opportunity for review, for relevance and proportionality. Finally, on remedy, the position that we've taken on relief, if you look at the core volume, at the very end of our case, paragraph 90 on 6024, for the reasons that I think the court understands and Mr. Southey had anticipated, there's a distinction between the multiple conviction rule and the serious offence rule, because we were not, and we've never contended that the serious offence rule would inevitably operate in a way that was incompatible. And so the suggestion that we make in paragraph 90 was, if the court accepts Mr. Southey's fundamental submission about the need to reflect the court's finding in terms of the 1975 order. A solution would be to read in to the order an exception which would ensure that there would not be automatic disclosure of listed offences in relation to under 18 offending. So they would then become protected convictions. They would then be liable potentially to be disclosed as soft intelligence under section 113B. But there is, we accept, and to some extent we've been, I think fair to say, slightly on the fence about the question of relief, that there's an obvious difficulty that so long as the Police Act scheme continues in operation and an ECRC or a CRC will be issued to an employer who asks for it and include the childhood caution, then the risk for anyone who doesn't disclose that they have, in this case, the caution that G has, faces the situation, well, if the CRC or the ECRC comes back, it'll tell the employer about it anyway. And so there's a question of the practicality of the situation in which you would take the risk of not disclosing it via self-disclosure because of the amendment in the 75 order that we suggest, meaning you would not be required to disclose it, but at the same time, unless and until the scheme were to be changed, it would be disclosed via the certificate. But if the court accepts the submissions that Mr. Southey's made, that is a solution in the case of the serious offence rule. Unless I can assist the court further, those are our submissions.
It would appear not, Mr. Owen. Thank you very much indeed. Mr. Whittaker? Well, thank you all very much indeed. It's been a long day, but it does look as if we shall succeed in finishing well before lunchtime tomorrow, and that will, I'm sure, be to everybody's benefit. Anyway, we'll look forward to hearing from you further at 10:30 tomorrow morning. Court is now adjourned.